Sir,
So why do I need to step out of this vehicle?
Because there's a Supreme Court case ruling called Pennsylvania v. Mims that a law enforcement officer can give you a lawful directive to exit the vehicle.
No, you don't.
Okay, well, I'm going to drag you out then. Yep.
Go ahead. Drag me out. Go ahead and drag me out.
Listen.
I'm calling my attorney. You can arrest. Hey, no, you ain't about. Hey, now you're going to mace me? Really?
This just happened in West Virginia. An innocent couple was just trying to get to work. They were pulled over by a police officer for going allegedly left of center. The officer wrote a warning ticket and then demanded that they step out of the car after that traffic stop was over. When the passenger refused, he was maced and pulled out of the car. Can police officers order you out of the car even after the ticket or warning has been written and delivered? I'll explain why this police officer does not understand Supreme Court case law as well as he thinks that he does. Also, I'll show you something really shocking that this officer posted to social media several days after this occurred. This is footage that was recently recorded out of Bellington, West Virginia, which is in Barber County, West Virginia, involving a guy named Vince and his longtime significant other. So Vince was the passenger in a vehicle. His significant other was driving him to work. He works as a nurse, I believe in a nursing home, and he really had to get there because the next shift was starting. They needed him. So it was a big hassle to get pulled over in this tiny town. On the way to work, he's going to be late. So the reason for the stop was left of center. The traffic stop went fine, really. They gave the information, and a warning was actually physically issued. So the stop was over. But then the officer says, now I want you both to get out of the vehicle. And he had to get to work. So he begins to then say, well, why do you need this to get out of the vehicle? And at that point, Vince picks up his phone. He starts filming. But I have the actual police report here. Let me read you what the officer says happened first, and then you can watch the video. So according to the officer, Deputy Christian Mail with the Barber County, West Virginia Sheriff's Office, he says, on June 2nd, 2024 at 1912 hours, I observed a dark in color Volkswagen Jetta commit a left of center violation. I initiated a traffic stop on the described vehicle in front of Hometown Pizzeria. I made contact with the occupants, later identified as blah, blah, blah. While on the initial contact, I observed both occupants to be extremely nervous, the driver's hands to be shaking fast, and the driver's hands to be extremely swollen, which is consistent with the overuse of injecting controlled substances. I inquired for the driver's documentation because she was the operator of the vehicle. She provided all documentation to this officer. I then verified the documents and returned them to her. I issued her a verbal warning for the traffic infraction and entered a secondary investigation. I inquired both subjects to exit the vehicle. Both subjects refused. Let's take a look at the footage.
Sir,
So why do I need to step out of this vehicle?
because there's a Supreme Court case ruling called Pennsylvania v. Mims that a law enforcement officer can give you a lawful directive to exit the vehicle. And if you
Under what circumstances? For driving left of center?
If you do not comply
No,
with that
you have no probable cause for me to exit this vehicle. You have no probable cause for me to exit this vehicle, Officer Mail, and you know it. No, you don't. No, you don't.
Okay, well, I'm going to drag you out then.
Hey, so if you want...
Okay, before we go any further, let's address Pennsylvania versus Mims. This comes up a lot in police interaction videos because Pennsylvania Mims is a Supreme Court case from 1977, and it's often cited for the right of police officers, if there is such a thing, to order people out of the car during a traffic stop, even though it only really applied to the driver in 1977. But I think this is overused in police training just to teach police officers that they can order anyone out of the car just for any reason. And that's not what Pennsylvania versus Mims held. And that's not how Pennsylvania versus Mims has been interpreted by the Fourth Circuit, which governs the federal case law here in West Virginia where this incident occurred. So let's make sure we're all on the same page about what Pennsylvania versus Mims is and what it does not do. So it all started with Terry versus Ohio, where a police officer then was able to basically stop and frisk somebody who's just walking down the sidewalk. The Supreme Court applied that same principle to a vehicle stop in Pennsylvania versus Mims in 1977. The court adopted the standard that an officer can frisk a validly stopped person if the officer reasonably believes that the person is armed and dangerous. So the Supreme Court applied Terry to circumstances of a motor vehicle stop in Mims, where an officer in Mims, after making a routine traffic stop, noticed a large bulge under the defendant's jacket and therefore conducted a frisk. The Mims court explained that the bulge in the jacket permitted the officer to conclude that Mr. Mims was armed and thus posed a serious and present danger to the safety of the police officer, adding that in these circumstances, any man of reasonable caution would likely have conducted the pat-down. The only evidence there of Mims's dangerousness was this bulge, indicating that he may be armed. It was thus Mims' status of being armed during this forced police encounter, i.e. traffic stop, that posed this danger that justified Mims being frisked. So in short, established Supreme Court law imposes two requirements for police officers to frisk somebody at a traffic stop. First, that the officer has conducted a lawful stop. That could be a Terry stop on the street, as well as a traffic stop. And secondly, that during the valid but forced encounter, that the officer must reasonably suspect that the person is armed and therefore dangerous. In both Terry and Mims, the Supreme Court deliberately linked armed and dangerous, recognizing that the frisks in those cases were lawful only because the stops were valid and the police officer reasonably believed that the person stopped was armed and thus dangerous. When Pennsylvania versus Mims is used as justification for bringing drivers out of a car, in order for that to be lawful, for that to be justified, those two elements must be met. One, it has to be a lawful stop. And secondly, there has to be some objectively reasonable information to the officer that the occupant may be armed and thus dangerous and needs to be frisked, patted down to see if he has weapons for officer safety. Now, I read you the report. Let's watch the rest of the footage and see if any of those elements are met here.
Hey, so if you want to, hey,
Drag you out. Yep.
go ahead, drag me out. Go ahead and drag me out.
Listen to Pennsylvania v. Mims.
No,
Get out of the car.
officer, I'm telling you, you have no right to drag me out of this car. You cannot just do that. You cannot just do that.
Get
You
out-
said
get
I'm
out of the
pulling you
vehicle.
over for left of
Yes,
center. No, I'm not stepping out of the vehicle until you give me a reason.
Okay, bud.
You want to give me a reason, then I will. No, that's a bunch of shit, and you know
Get
it,
out of the
Officer
fucking
Mail.
car.
I'm
out
calling
of
my
the car.
attorney. You can arrest. Hey,
Get out of the
no,
car.
you ain't about. Hey, now you're gonna mace me? Really, really, guy? I'm not attacking you. I'm not doing anything to you, and you mace me?
Now get out of the car.
What'd you call me, a motherfucker? I'm not getting out of shit until he tells me why.
Hey, William told him, get out of the car.
No, not until he tells me why I need to exit the vehicle.
Because that's the law. That's
No, it is not the law.
It is federal case law, Pennsylvania versus.
No, it is not.
It's federal. Shut up.
Hey, don't tell her to shut up.
So there you have it. That's the end of the video. Violence was used, physical force was used, injuries were caused, criminal charges were filed against both individuals. Those criminal charges are still pending. Turning back to the police report, it says, this officer inquired both subjects to exit the vehicle. Both subjects refused. This officer advised the subjects of U.S. Supreme Court case law, Pennsylvania versus Mims, in order to better explain why this officer was requesting the occupants to exit the vehicle. Well, Pennsylvania versus Mims, as I explained, requires a lawful stop, number one. And secondly, it requires some objectively reasonable belief that the individual may be armed and therefore dangerous. So it's not just you can order somebody out of the car because they have to respect your authority and you're allowed to do that. It has to be based on a legitimate and objective concern for officer safety because, for instance, I observed a bulge. There were no facts alleged in the police report which brought forth any officer safety concern. The only facts that were alleged had to do with his drug investigation. So he says that both occupants appeared to be extremely nervous and that the driver's hands were shaking and the driver's hands were extremely swollen, which he believed was consistent with the overuse of injecting controlled substances. So that's it. There are no allegations that there was officer safety concerns because the individual may be armed. And you can see from Googling this officer that he's one of these drug interdiction guys. He's got a canine, which he uses to sniff around vehicles. And it was later revealed during the arrest processing that he wanted them out of the vehicle because he was going to run his canine around the vehicle. So what Pennsylvania versus Mims does not do is allow a police officer, especially after the stop has already ended, to just order people out of their vehicle so he can run his canine around the vehicle and perform a drug investigation, especially where the original stop was for going left of center, and that stop ended. Now let's look at that. Again, Pennsylvania versus Mims, as the first requirement, requires a lawful stop. The stop here was due to going left of center. Prior to even mentioning Pennsylvania versus Mims or ordering them out of the vehicle, that stop ended because he wrote a warning citation, he admits in the police report, and delivered it to the driver before he ever ordered them out of the vehicle. He wrote that he then entered a secondary investigation. Can he do that? Here we can look at the controlling Fourth Circuit case law, and there's a lot on this topic. If a traffic stop is extended in time beyond the period that the officers are completing the tasks related to the traffic infractions, i.e. left of center, the officers must either obtain consent from the individuals detained or identify reasonable suspicion of criminal activity to support the extension of the stop. The authority for the seizure ends when tasks tied to the traffic infraction are, or reasonably should have been, completed. The Supreme Court has said that extending a stop by even a de minimis, a very small amount, length of time violates the Fourth Amendment. That's the Rodriguez case. An officer may engage in certain safety measures during a traffic stop, but generally must focus his attention on the initial basis for the stop. An officer may engage in ordinary inquiries related to the traffic stop, such as inspecting a driver's identification, verifying the registration, verifying the insurance coverage, determining whether the driver is subject to any warrants. And while diligently pursuing the purpose of the traffic stop, officers also may engage in other investigative techniques unrelated to the underlying traffic infraction or the safety of the officers. But such unrelated activity is permitted under the Fourth Amendment only so long as that activity does not prolong the roadside detention for the traffic infraction. The Fourth Circuit writes, for example, an officer may question the occupants of a car on unrelated topics without impermissibly expanding the scope of a traffic stop. An officer may also engage a canine unit to conduct a dog sniff around the vehicle during a lawful traffic stop in an attempt to identify possible narcotics. However, again, Fourth Circuit, controlling case law here, because such a sniff or investigative questioning is intended to detect ordinary criminal wrongdoing, these actions may not prolong the duration of the traffic stop, absent the consent of those detained or reasonable suspicion of criminal activity. Here, the officer admits in his police report that the traffic stop related to going left of center was over. Therefore, he either needed the consent of the individuals, which clearly he did not have, as demonstrated by this video footage, or he needed independent, reasonable suspicion to detain these folks based on suspicion of criminal wrongdoing. Here, he's suspecting drug use. Perhaps if he had pulled his canine out and had the dog sniff the car during the ordinary procedures of the traffic stop he was engaged in, that combined with what he allegedly saw, perhaps could be enough to take it further in a drug investigation. But he chose to wait until after his initial traffic stop was over to then begin his drug investigation. The problem was the individuals were no longer legally detained pursuant to that traffic stop, and he didn't have enough reasonable suspicion or probable cause for any sort of drug investigation to then further detain them or detain them again for a drug investigation. And they had no drugs. The only drugs that were found in the car were the lawfully prescribed prescription medications that this nurse was taking to work with him that he takes every day. Of course, he was still charged with that because they weren't in their original pill bottles, but they were in his pocket or something. I don't know. So these people were not free to leave. They were ordered out of their car. Pennsylvania versus Mims was used as justification to order them out of the car. However, there was no lawful stop, and there was no indication that the individuals were armed and therefore dangerous. Therefore, it does not fall under Pennsylvania versus Mims anyways. And none of that justifies violence being used to pull these innocent citizens just trying to get to work out of their car, for which this officer bragged on Facebook in a post that I believe now has been taken down. This is what he said. Just several days afterwards, this was put up on Facebook, I believe is what prompted this. It put up on Facebook. It got like 40,000 views or something locally, and people were discussing it, and people were upset. Others were coming to the defense of the police officer, saying one should always comply when given instructions or orders by a police officer. So this officer, Christian male, put a Facebook post up saying, "Forever striving to be the most protective, dangerous, and kind-hearted version of myself for my family." Then that was later taken down, apparently. And looking at his publicly available Facebook stuff, I think we get an idea of why this really happened. This is really a case of respect my authority, and it's sort of him losing his temper and going on a power trip here. A lot of police officers are into steroids. And I only say that in regards to this case because if you look at the last post on his Facebook page, it says, "Feeling anabolic this evening, get better," or GTFO. And then he's standing there with like his gym buddy in the gym, and he's holding a gallon jug of water. Now, I've spent a lot of time in the gym. I was a college football player. I have been an amateur strongman competitor. I've spent much of my life in the gym. So that's him on June 7th of this year, just a few days ago. Compare that to the picture of him with his dog in May of last year. He's gotten much bigger. He said he's feeling anabolic. Does that mean he's taking illegal steroids? I had to be tested in college football. Do we not test police officers? Has he been tested? Should he be tested? After putting that up on Facebook. After all, he's interacting with the public. Look how he went 0 to 11 dealing with these just two innocent people trying to get to work in a nursing home. Why would it not be a good idea to have your police officers using steroids? Well, they might fly off the handle 0 to 11 when interacting with the public.
No, you don't.
Okay, well, I'm going to drag you out then.
Instead of just saying, well, here's why I would like you to step out of the car because I want to run my drug dog around your car. Do you have any drugs in the vehicle? Hell, he didn't even ask Vince for his ID. Just went 0 to 11. Very immature, very, very roid-ragey. I suspect that there are other incidents out there. If you have other incidents you're aware of, other video footage involving this officer or this department, please send them my way. I'll definitely be investigating further and do an update video when the body cam footage is released. Because there's a criminal case, and I'm not his lawyer or anything. I don't even know who his lawyer is. They're not going to release the body cam footage except to the lawyer. So perhaps we'll get it at some point, and I'll do an update video, and that will have additional information for sure. Please subscribe at thecivilrightslawyer.com. If you have a video you want me to review, use the submission link below. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.